Did you know that most businesses are built backwards? That's the conversation today. We're going to get into it and talk about how those businesses are actually built backwards and what happens. So, most entrepreneurs follow the standard advice online and on social media, and that is to start an LLC, secure an EIN, and begin operating. But that's not, and after the EIN, to get a business checking account. But that's not the way that things are supposed to go. That's providing no consideration as to whether or not your valuable business assets should be separate from the operating risk. We're going to get into it and talk about that. Most businesses are operated in this manner because when forming, the entrepreneur does not give any thought to what should control the assets, not who should control the assets, what should control the assets. Where should ownership sit? Those are the questions because not giving consideration to those things first actually takes things out of order. There is no requirement that an LLC or a corporation be formed in order to begin doing business. There's absolutely no requirement for that. Those are called sole proprietorships. Any business owner can begin operating and providing goods and services at any given time. However, in order to protect your personal assets from the business operations, then either the LLC or the corporation must be formed. That's the purpose behind limited liability protection. And for purposes of our conversation, limited liability protection has the same meaning, whether it is the corporation or the LLC. It means exactly the same thing. If the business activity causes harm or injury, then your personal assets are going to be safe if if the operator of the business respects the business protocol. That is, not mixing funds, paying personal expenses out of the business account, or vice versa, injecting personal funds into the business to pay business expenses. That's called commingling. The protection that is derived from limited liability companies or corporations is not automatic. The protection doesn't happen simply because the business is formed. That's a big misconception of many business owners, that the protection occurs merely because there is a business entity that's been formed or that there is paperwork that exists. Those things in and of themselves do not provide protection. Protection is conditioned upon how the business is operated. Are funds maintained separately? Does the owner or operator act as a guarantor for business transactions? Who provides authority? How are those transactions entered into? Are they signed contracts on behalf of the business entity by the owner, but in the owner's representative capacity? Or does the owner lapse in and out signing those transactions in a personal capacity? That is what limited liability protection is conditioned upon. The business owner must operate the business properly. Otherwise, there will be no protection. Now, again, so the question often arises, what does forming the LLC or corporation provide? The answer is that it provides a container. Think of it that way. It provides a container from which you operate the business. And what you place inside that container is going to determine at some point in the future whether or not there's actual limited liability protection. So the things that are being placed inside the container from time to time are those transactions. Think about a business that's operated for a number of years, 3, 5, 10 years, and all of the things that the business owner does in the business within that time frame, entering into leases, signing contracts, acting as a personal or providing a personal guarantee for business funding, purchasing insurance, insuring assets. All of those transactions are going or sending out a signal, if you will, and then being going into the to be read at a future time by any number of institutions that the business engages with. Now, the owner during the course of that time period operating and entering into those transactions is not aware in most instances of the concept of these things are going to be read at a future time, sending out those signals. But whether the institution is a bank, if you're applying for a bank loan, or the courts, if you're engaged in litigation or some type of conflict, or whether the institution is um, insurance companies, when we apply for insurance coverage for the business as well as the business assets, the insurance underwriters want to know who owns. How is the business equipment titled? Um, Real estate underwriters are picking up those signals when the business moves to sell a real property asset, or it could be investors doing their due diligence to discover who owns, who controls, whether or not there is written authority in place in the event that the business owner has to step away voluntarily or involuntarily. Now, all of those institutions have their own particular process for determining, reading those signals to determine one thing that they all share in common. And that is they're all trying to determine whether or not the business operates independently of the owner. That's what they're trying to determine, whether or not the business operates independently of the owner, or whether the business is, in fact, dependent upon the owner. Now, if we're talking about banks, insurance underwriters, those types of individuals, those classifications. So when they're picking up the signal, when you go to the bank, when the business goes to the bank to apply for the loans, now the signals are there. All of those transactions. For instance, when the bank asks for P&Ls, bank statements, tax returns, those are the signals. Now they're going to be read. Those things have been maintained and created, or created and maintained over the course of the number of years that the business has been operating. Now those signals are going to be interpreted by the bank. And the bank is looking to determine whether or not the business operates independently. And that means independently of the owner. And that means whether or not what happens if something goes wrong with the loan. If the loan is not repaid, who's going to be responsible? And so it is looking at things such as whether or not the business generates sufficient revenue to operate independently, or whether or not the owner injects cash into the business in order to shore the business up when things are slow. Those things matter. And if if the bank determines that the business doesn't operate independently, then the bank is going to protect itself, right, by the terms that it may offer the business owner. The bank may ask for a personal guarantee, or the interest rate offered may be adjusted upwards if if the business is not independent. Or in some instances, credit may be denied based upon that. So whether or not the business operates independently is a big deal. Now, if we're talking about the situations in which the lack or the absence of independence can be fatal, that is when we're talking about confrontations and litigation. If we're talking about litigation, then the courts are asking questions for the same purpose. Who controls the business? Who stands to benefit from the activity of the business? Who has the final authority to bind the company? And probably most important of all, how does the money move? Because money generally moves with authority. And if the answer to all of those questions lead back to the business owner, then the courts are going to determine that the business does not operate separately from the owner, that the owner is in fact the business. And if that's the case, if that's the classification that happens, then the court is going to pierce the corporate veil. Maybe you've heard or familiar with the phrase or heard the phrase before. And piercing the corporate veil means that after liability has been determined, after the case is concluded and the court determines that the party at fault is the business and liability is imposed there, the other side is going to be making an argument that also that the business does not operate independently from the owner, that those signals, those transactions show that the business and the owner is one and the same. And if they're able to convince the court that the business and the owner are in fact one and the same, then they are going to pierce the corporate veil. And piercing the corporate veil means that they are going to impose the responsibility for repayment upon the owner. Okay? Because the whole purpose behind forming the LLC was to create that separation between the owner's personal assets and the business liability. So now here we are. Liability has been imposed on the business. The owner's personal assets are over here. And the other side, the judgment creditor, the party who sued and won, they're saying that the personal assets should be at risk because should be exposed for satisfaction of the judgment because there's no distinction between the owner and the business. So they should be able to recoup their losses from wherever they find them. That's why it's so important that business owners understand how to operate. If you're just joining us, the conversation for today is most businesses were built backwards. Most businesses were built backwards, and we're talking about how that happens. Most business owners follow the advice online and on social media, form an LLC, get an EIN, open a checking account, and start operating. Let me say this, guys. If you find value in the content that we provide here at Law School, please like and subscribe to the channel. That's all we ask. It affords us the opportunity to have the information sent out to a broader audience. So we'd appreciate if you consider doing that. Please like and subscribe to the channel. So that is why how most businesses are built backwards. Now that we understand what that looks like, so the next question that arises is, if your business was sued today, what could they take from you? If your business was sued today, what could they actually take away from you? And the answer that most business owners provide in response is that I'm protected. My LLC is current. I file my annual report on time every year. I pay my annual fees on time every year. I'm protected. I'm in total compliance. Well, compliance answers a different question than protection. Okay? Compliance answers a different question than protection. Compliance simply says that the business owner has performed the minimum requirements necessary to be recognized by the system. That's all it says. It doesn't answer the question of protection. And that question is, what happens when something goes wrong? What's at risk? What's at stake when something goes wrong? And so not only are most businesses built backwards, but many business owners are totally exposed because the purpose behind forming the LLC is simply to create one layer and one layer only. And that layer exists between the owner's personal assets and the business liability. And that protection is conditioned upon how the business is operated. So, in fact, even if you have an LLC, there's the real possibility that the purpose for which you established the LLC and benefit for which you established the LLC is non-existent. If we don't know, if we don't know how to operate, it's non-existent. Now, here's the other side. Here's the other side. If all of your valuable business assets sit inside that LLC because you as the business owner were unfamiliar with the fact that business assets should not be owned by the operating company, then those assets are totally at risk. They have no protection. And that's one of the biggest misconceptions by business owners. Business owners think that once they file the LLC or the corporation, everything is protected. But it doesn't work that way. It only protects your personal assets if you operate the business properly. So here's what that means. That means that from day one, if real estate, business equipment, your trademarks, intellectual property, transportation equipment, whatever the business use, cash reserves, accounts receivables, all of those things owned by the business are exposed to liability immediately. They have absolutely no protection. There is no shield for those assets. And that's because those assets were placed in the same container as the risk. You only have one container. When you form the LLC and you operate out of that LLC, then there is no protection for those assets because the assets and the risk are in the same container. It's like placing everything that you've built in the same room with everyone that you owe. And so when it's time to pay, when it's time for them to collect, they are going to have access to those assets immediately. There is no shield there. And that's why when we're talking about most businesses are built backwards by simply going straight, forming the LLC, getting an EIN, opening a checking account, and begin to operate. But let's talk about what built forward looks like. Built forward means that the business owner or operator actually gives thought to where those valuable business assets should be located. What should own and not who. That's the holding company. So what does built forward looks like? If built backwards means that we went straight and got an LLC and began operating, that's the foundational level. But in actuality, we should have separated the ownership from the assets, and the assets should be separate from the risk. So there are actually two layers. There's the layer between ownership and assets, and another layer between assets and operating risk. And those are ownership is contained in the trust. The trust holds the beneficial ownership. Who stands to benefit from the activity without actually having the owner's name on the business. That's one of the purposes of that, as well as to avoid probate, to provide for continuity of the business. Excuse me. The second layer is the holding company. That's where assets should be located. And they're protected because the holding company doesn't do business. It does not have customers. It doesn't sign contracts. It doesn't hire employees. Its only activity is to control the operations and to own those valuable assets that are used in the operations to create that shield. And then we have the operating company where the risk lives. That means that if anything is to go wrong, it's isolated there in the operating company. And only the operating company will be responsible for resolving any harm or injury there because the operating company caused that harm and everything else was above and isolated. That's the structure. That's the structure that you see and hear about online all the time. Owning nothing, not having your name in the line of fire, and yet still being able to control those valuable assets because they're owned by the holding company. Still, your name's not there on the holding company, and still being able to control the operations because the holding company owns and controls what happens at the operating level, and there are no personal names there as well. That's the strategy. That's how assets are protected. Now, depending upon the complexity of the operations, the number and value of the assets, there may be a need to have multiple LLCs as well as more than one holding company. That just depends upon what your setup is, how complex your operation is. For many business owners, though, just getting started out, the trust, the private trust, is the holding company, and the operating company, LLC, is sufficient to provide asset protection. But again, it's very important that the business owner understand how to operate, not to mix funds. Acting as a personal guarantee for the business is sometimes necessary for funding, but understand that when we decide or make the decision to act as a guarantor for the business, we sacrifice or waive the limited liability protection as it relates to that credit or debt in the event that something goes wrong. That's just a conscious decision. But in other areas like signing contracts and leases and um, how we deal with employees, whether in fact they're independent employees, independent contractors or employees, all of those things matter. And all of those things send out signals that are going to be interpreted when something happens, when something goes wrong. And what business owners need to understand, very important, is that business structure is not tested until there's a problem or a pressure event. If we're talking about a conflict, litigation taking place in court, or partnership conflict, employee dispute, business structure is being tested at that point because the questions are going to be asked in order to determine whether or not the business is separate from the owner. And in many instances, if it is not, it can be fatal for the business assets as well as personal assets. Again, answering the question, if you're just joining us, if your business was sued today, what could they actually take from you? And for many business owners, the personal assets are at risk, as well as those assets owned by the business and used in the operations on a daily basis, because the assets in the business are not separate from the risk. Forming the single LLC does not protect those assets. They remain exposed. And many business owners are not aware of that level of exposure. Many owners think that forming the one LLC protects everything, and all they have to do is comply with the state requirements on an annual basis. But it goes deeper than that. It goes deeper than that. There must be separation between not only personal assets and the liabilities, but there must be separation between business assets and the operating risk. That's important. That's how legacy is maintained, because those business owners, they don't lose assets. If something happens and liability is imposed upon the business and it is structured properly with the trust, ownership at the trust level, assets at the holding company level, and the operating risk isolated at the LLC level, then when that liability is imposed, if everything is structured and operating properly, those assets are going to remain safe. And that business owner may lose the entity. What I mean by that is we may have to dissolve the LLC, the entity that you operate out of, because that's the one that was found liable. So it may be dissolved, but the assets remain safely tucked away. And what happens in those instances is that the business owner forms another entity from which to operate a new container, but the assets are still there and safe. So the transition to the new container is easy because you didn't lose anything. It's important to understand that. And many business owners don't understand that because they think they are under the impression, operate under the impression and illusion that success means that they're not exposed. If the revenue in the business is growing year over year, they're hiring employees, buying new equipment, maybe even scaling the operations. But all of those things can exist at the same time, and pressure or exposure is present. And that's because success has a way of masking or hiding exposure. It does. Because nobody's looking, nobody's contesting things at that time. That's how that's occurred. Now, this conversation is usually can be difficult for some business owners. If you're operating and you see the manner in which you operate and some of the things that we're describing here today about how money moves in the business, whether or not expenses are documented, if there's a system in place for taking draws or distributions, acting as a guarantor for the business, signing in your personal capacity on behalf of the business. If any of those things look like your operation from time to time, then your personal assets may be exposed. But the larger awareness for many business owners is the fact that their business assets are totally exposed. That's not even a question about how they're operating the business. If a judgment is rendered, those assets are immediately reachable, in addition to the possibility of personal assets being reachable dependent upon how the business is operated. And so, if that is concerning for you, however, you don't have litigation or anything like that present right now, there's no pressure event, then consider that as an awareness. And you can use that awareness to structure your business properly. That's why I talk about the pro sepreneur. And that's what we're involved in here at Free Law School with that movement. You may be familiar with the phrase pro se. You may have heard it before. It refers to the person who represents his or herself in court. Okay? Now, we're not talking about the business owner representing his or herself in court. The meaning of the word or phrase pro se is for oneself. And we know who the entrepreneur is, the business owner that operates the business operates his or her business. Now, the pro sepreneur is that business owner who wants to take responsibility for his or her own structural literacy, understanding how your business moves and operates in the business and legal environment. It's a must. It's a must for keeping those assets safe because no paperwork alone is going to protect the assets. Whether or not your business is classified as personal or separate is going to depend on how you operate, those signals that you're sending out each and every day based upon the transactions that you're engaging in on behalf of the business or purportedly on behalf of the business. That's how it's going to be determined. So it's important that the business owner understand how to move, how to engage in those transactions in order to stay on the right side of the line when it comes to separation versus personal. That's how we stay safe. And so that's the pro sepreneur. That's the person that we're talking Two, who is going to take action. And again, if you're just joining us, and if you find value in what we're talking about here this morning about business structure and how to protect your assets, please give us a like and subscribe to the channel. It helps us. It helps YouTube to understand that the information is valuable and that they'll afford it and push it out to a broader, larger audience. So we really appreciate you for taking the time to do that. There's a question in the chat. You can respond to it. The question is, do you have questions about trusts and LLCs? That's the question. It's in the chat. You can put those questions in the chat and we will address them. Or what other issues you'd like to see Free Law School address in our content, our long form content, shorts, or lives, actually lives. So that's what we're talking about. How businesses, most businesses are built backwards, and that you can fix it. If you're intent on doing something with the awareness that has been created regarding the potential exposure in your business, you can do something about it. And so we created a tool. We've created a tool, the Structural Exposure Diagnostic. The link is in the description. The link is in the description, and it's complimentary. It's for those business owners who may see a reflection of themselves and how they operate the business and what we talked about, how they sign, how they move money, whether or not control ownership is separate from control, whether or not there's business continuity is set up. The diagnostic will provide an assessment of where your exposure may lie. Now, when you're taking the diagnostic, it's important to understand that you're going to answer those questions based upon how you're actually operating the business now. There's nothing there personal. They're all operating type questions, inquiring into how the business is actually operated. And when you complete that, it is going to tell you the categories of where your exposure lives, whether it lives at the ownership level, the control and assets level, risk, or continuity. And when you complete it, you can download it because we don't maintain them. And so if you're intent on acting upon the awareness that's been created, then schedule a call. If you'd like to work with me, you can send me a DM, send me a message on Instagram, connect with us on Instagram. Our Instagram handle is in the description of our videos, long form videos. And so we can talk, get on a call and map out your structure. Okay? It's not a sales call. It's not a consult. It's to take that diagnostic, map out where your exposure is, what that actually looks like, what activity it might be coming from, and discuss mapping out how to fix it. Okay, so the link is in the description for the complimentary diagnostic. And if you'd like to talk about the results of the diagnostic, send me a message at Free Law School on IG, and we'll connect and talk about fixing your business structure. I hope this information has been helpful to you guys. Again, please take the time to like and subscribe to our channel. And we'll see you in another conversation.